Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
And good morning, America. Good morning, other great places throughout the Midwest, including right here in Wisconsin and the great place called Waukesha. My name is Jim Santel. It is Saturday, June 4th. It's the 153rd day of 2022. How exciting is that? I am delighted to be with you this morning. Thank you so much for joining me for this inaugural program, this inaugural broadcast of what we're calling Morning Cannolis with, yes, me, Jim Santel. I'm going to talk to you more about the definition of what this program is all about, where that name comes from in just a few moments. But let's begin today with looking back at a few historical things in our nation's history, our world's history. It was way back in 1912 on June 4th that Massachusetts first passed a minimum wage law. The first time in the United States of America we had a minimum wage law way back in 1912. 1945 was the year on June 4th that the United States, Great Britain, France, and the Soviet Union agreed to divide up occupied Germany. Many people regard that as the start of the Cold War. 1945 on June 4th. Other significant events on June 4th. Way back in 1989, 33 years ago, the horrific events of Tiananmen Square, and to this day, reverberating around the world, including in China, as the government there tries to suppress even any recollection of what happened on that day 33 years ago, June 4th, 1989. 1992, a little bit more recent. United States framework, the UN framework convention on climate change was signed in New York City, initiating a lot of our national and our worldwide focus on this very important issue. 1992, 2018, not too long ago at all. Things we talk a lot about here at WAUK. Donald Trump tweeted, "I have the absolute right to pardon myself." Perhaps we'll talk about that down the road as well. 2020, just a couple of years ago, was the day. June 4th today was a memorial held in Minneapolis for George Floyd and the horrific event, the civil rights event, the deprivation of his life, kicking off protests and perhaps one day some reform when it comes to policing and law enforcement generally in America. And not to be outdone by the past history, we've got something from just today. This is the first weekend today, the first Saturday in our nation's history when you can go to Washington, D.C. and check into what is no longer the Trump Hotel on the corner of 14th and Pennsylvania Avenue right there. It's been turned into a new hotel. It's now the Waldorf Astoria. 263 rooms opening a couple of days ago, including today, the first weekend that it's open, now called the Waldorf Astoria. And for a very modest $1,000 or so, you can get a room there right in Washington, D.C. So all those events happening on June 4th, also happening on June 4th. Yes, that's right. This is the inaugural broadcast, the inaugural discussion, our group together today, you, me. I've also got Connor here as my producer right here in the studio in downtown Waukesha on the streets of Waukesha right here in Wisconsin Avenue. Connor is here with me throughout the next 2 hours, and we're going to be chatting about a number of different things. As you heard in the intro, we're going to be sampling the news desserts of the week. We'll get back to that in just a few moments or so. Kind of a weekend review of many of the significant issues that we've talked about, stories that have influenced the nation, our state, our locality, and our world for the past week. And then also focusing on one or more of those issues in a major way, in a way that perhaps we haven't talked about during the course of the week itself. Very, very excited to have you with me today, and Connor also today, as we are in the WAUK studios right here in downtown Waukesha. This is 540 AM, 101 FM, The Shaw in Waukesha. And again, my name is Jim Santel. I have had the great honor for the past 4, maybe even closing in on 5 years, to spend a great deal of time in this studio, also in the studio in Madison, the studio in downtown Milwaukee, formerly on Brady Street, spending some time with you and especially with Mike Crute. and with Dom and others talking with you about the current issues of the day. I'm hoping that Mike will continue to invite me, as will Brian and Connor and Dom and others here, back on a regular basis during the course of the week to talk about many of those significant issues as they break in news. And that will not stop. And I'm looking forward to that here just this past week, both on Wednesday and Friday, chatting about some of the current events that you are also concerned about and focused on a regular basis. That will continue. That will continue if indeed Mike and others invite me back. I have every reason to believe that that will happen. But we are today starting this brand new program, 9 o'clock to 11 o'clock, right here at WAUK 540 AM, 101 FM, the Shaw in Waukesha. I am typically going to be here in the studio, although, as you know today, much of the programming coming out live from the Shaw is right here at the Waukesha Farmers Market. You heard Don right before this program began, along with Mike, at that farmers market, 125 West St. Paul Avenue. It's along Fox River, the Waukesha State Bank parking lot right over there. And we go back there at the end of this 2-hour period. Encourage you very much to be a part of that important community event, knowing that you always have a voice here at WAUK, whether you're calling in sometime later in this program this morning, during the course of the week, many of the other programs here on WAUK, and also visiting wonderful people like Mike and Don and others at that Waukesha Farmers Market today and at future Saturdays. Very exciting here in the city of Waukesha. And again, I am professionally honored, personally delighted to begin today's program, starting some time with you on a regular basis. Virtually every Saturday morning, I'm going to join Connor here in the studio, or perhaps sometimes at the farmers market during the course of the summertime, talking about some of these critical issues that we have not chatted about a lot during the week, at least not in the depth that we're going to go into on these Saturday morning programs. And so today I'll tell you a little bit more about what we're going to do. I'm going to talk to you a little bit more about who I am. For those of you who have not heard from me before, I welcome you to this program. Looking forward to a continuing, wonderfully productive, wonderfully engaging conversation with you, getting callers to call in and talk on a regular basis about their questions, their comments or observations about many of the topics that we'll raise. Looking forward to that very, very much. And as I said at the outset, as Connor told us at the outset, we're calling this Morning Cannolis. Where does that phrase, where does that title come from? Well, you should know that a couple of years ago, when Mike and Dom invited me to one of their anniversary programs just outside of Madison, we were celebrating the fact that they have been on the air for a significant time. Important commentary in Wisconsin, other places throughout the Midwest, certainly in this part of the nation. And so on that particular day, as I was heading out to Madison, I decided to stop at my baker and picked up some cannolis. And so we celebrated with cannolis both on the air and off the air. Those of you who listened during the course of the week may recall that from time to time, Dom and Mike will chat about cannolis, and that has been a continuing great issue for us to chat about, even as our focus has principally been on even more serious issues. And so when Mike, a number of weeks, actually even months ago, approached me and said, gosh, Jim, maybe there'd be some opportunities for us to improve and even build upon even more some of the discussion that we have in the week. We talked about that a lot and began to put together the format for what is starting this morning as Morning Cannolis. Needless to say, the very clear and unmistakable and absolutely important way of describing the morning was to describe it as Morning Cannolis with me, Jim Santel. And so that's where the title comes from. And this morning, I will tell you, I stopped by my baker once again, consistent with Mike's commission to this wonderful program for the next couple of hours. Stopped by my baker to get the cannolis so that both Connor and I could have a morning cannoli with you as we're talking about these issues. And lo and behold, on our first inaugural day, my baker said to me, Jim, very disappointed, the shells didn't come in. So I'm certain I'm going to hear about that from Mike and from Madame and from others. And so instead of cannolis this morning, much to my disappointment and perhaps to Connors as well. Instead of cannolis, we're enjoying crullers here this morning, also a uniquely, maybe not completely unique, Wisconsin delicacy. In the future, cannolis, both here in the studio, WAUK, on Wisconsin here, also in other places. And so that's where the name comes from, and that's where we're going to be doing for the next probably in the future, certainly next Saturdays, both here at the studio and also down the road at the Waukesha Farmers Market. I have been greatly honored during the course of the past 4 to 5 years to be a regular participant with Mike and Dom and others on this great show, on this great program, Waukesha, and other places throughout the Midwest, including Wisconsin. I thought I'd spend just a few more minutes before we go to our first break this morning, tell you a little bit more about who I am. I am a lifelong resident of Wisconsin, grew up in Milwaukee, grew up in suburban Milwaukee, but spent most of my career, as I will tell you in just a moment, in Milwaukee, Wisconsin, where I have pursued my profession as a lawyer. I grew up in the public schools in Waukesha. I'm a graduate of Brookfield East High School, and then went on to Marquette University, where, believe it or not, they gave me a degree in English and history after about 4 years or so of studies, and then decided to head south. Went to the University of Chicago in Hyde Park in Chicago for a couple of years at the law school there. And a little bit of a tease for something coming up. One of the professors I had there was a fellow named Antonin Scalia. We're going to talk about him in the second portion of our time this morning. But he was one of my professors at the University of Chicago. After that, I came back home, as my parents said at the time, and began a 2-year clerkship with a wonderful judge named Robert Warren. Many of you may remember him, former Brown County District Attorney, former Attorney General of the state of Wisconsin, and spent 2 years with him. And then after that, fell into what many of my friends and partners and colleagues in the profession described as a 3-decade rut in the U.S. Department of Justice. Actually, not a rut at all. Greatly honored, again, to serve as an assistant U.S. attorney for many, many years, and then also during the course of the Obama administration, serving as the United States Attorney for the Eastern District of Wisconsin. And so that brings me here. We'll tell you more about that and my connections to Wisconsin coming up in just a few moments. This is Jim Santel. I'm with Connor here in the studio. Morning Cannolis with Jim Santel here at the studios, WAUK 540 AM, 101 FM, the Shaw in Waukesha. Delighted to be with you. Thank you so much for joining me. And right after the break, we're going to start in earnest in our discussion this morning. Also inviting you to participate, questions, comments along the way. Thrilled. This is Morning Cannolis with Jim Santel, WAUK Waukesha. And we're back. This is WAUK Waukesha, 540 AM, 101 FM. It's the Shaw in Waukesha. My name is Jim Santel, and you're tuning in to our inaugural program this morning, our inaugural broadcast of Morning Cannolis with Jim Santel. We're going to be sampling, yes, that's right, the news desserts of the week. How cute, how appropriate is that? It's going to be a weekend review of some of the important stories, undeniably with a great deal of focus on things like law and government and, frankly, the aspiration for justice in America. Lots of things we've chatted about during the course of the week. Now also on Saturday mornings from 9 to 11, Morning Cannolis with Jim Santel. Again, my great thanks to the station owner, operator, producer, guru, Mike Crute, who's invited me to be with you this morning and in the forthcoming Saturday mornings to chat with you, going a little bit deeper into some of the issues we've talked about during the week, not to the exclusion of my participating in some of the other discussions during the course of the week itself. I'm here in the studio today, right on Wisconsin Avenue, here with Connor, who's my producer. And in a little while, we're going to be also soliciting your comments and questions at the number 844-967-2789, 844-967-2789. But right before the break, I was talking with you not only about our commission, what we're going to be doing in the course of these Saturday morning programs, talk to you a little bit about where that name comes from, the cannolis that almost, Connor and I are enjoying this morning. We got a substitute cruller here, but cannolis regularly on Saturday morning. Encourage you to join in that as well. And then also chatting with you a little bit about who I am. And for those of you who are new to this particular program, that's everyone, but new to hearing me, this is Jim Santel. And as I said right before the break, spent about 30 years as a civil litigator and criminal prosecutor on behalf of the U.S. Department of Justice, principally here in the Eastern District of Wisconsin, in Milwaukee and the other counties in the eastern portion of this state, but also spent a good deal of time at so-called Main Justice in Washington, D.C. I mentioned right before the break one of the significant events today that's happening is we no longer have a Trump Hotel in downtown Washington. Instead, it's become the Waldorf Astoria. That hotel is actually about 3 or 4 blocks just directly west of the Main Justice building, right there on Pennsylvania Avenue. You see it on a regular basis in cable news stories, on shows, that sort of thing. And certainly when presidents in their inaugural walk down Pennsylvania Avenue, you see the building in the background. But I spent about a couple of years there. I'm very honored once again to have worked for a former Attorney General named Janet Reno, and served there in an office called the Executive Office for United States Attorneys. And at that time also got to know another fellow who was the Deputy Attorney General of the United States of America at that time. His name is Eric Holder. And of course, you know that Eric Holder then became the Attorney General under Barack Obama. And it was during that period of time, as I mentioned before the break, that I had the great honor, the great privilege to serve the people of eastern Wisconsin and all of our U.S. attorneys. We always say the entire nation, serving as the chief federal law enforcement officer in our specific district. And so for me, that was the Eastern District of Wisconsin, the easternmost counties, if you will, throughout the state, serving under Eric Holder, who is a frequent visitor to Milwaukee, to eastern Wisconsin, and hopefully we'll be back again on a regular basis. But a great pleasure to work for Janet Reno, also for Eric Holder. And I will also mention that during the course of my 30 years or so as an assistant U.S. attorney and then as a U.S. attorney, I worked for 9 different attorneys general. And they're Republican and they're democratically appointed. Both parties bring their attorneys general to that Main Justice building, to the nation as chief national law enforcement officers. And I will tell you, as I've said before, and it's going to color a lot of our discussions this morning and also down the road, that when it comes to prosecutions, when it comes to the importance of doing that role, the Department of Justice necessarily needs to be independent of politics. And although we had some significant breaches of that fundamental concept in the prior administration, it was my great pleasure and great experience not to be affected in any way by partisan politics or other things that might otherwise influence inappropriately through politics or other sorts of inappropriate bents or perspectives on the world. Law enforcement should not be that. It should be the enforcement of the law for all people, regardless of party, regardless of partisan affiliation, or any other immutable characteristics that make us great as Americans. All those things should animate the U.S. Department of Justice, any Justice Department, any law enforcement office throughout the United States of America. Great pleasure for me to serve in all those capacities. I also spent some time in Baghdad, in Iraq, 2006 and 2008, serving as the Justice Attaché and the Rule of Law Coordinator. At that point, Attorney General Gonzalez was the Attorney General and had an opportunity, obviously, to spend time with him there and also in Baghdad, an experience I've also chatted about from time to time, working with Ryan Crocker and Zalmay Khalilzad, who were the ambassadors at that time. Also an experience given to me by you, the people of this nation, by the people of the U.S. Department of Justice, plainly something that colors and animates me to this day when we chat about war, which we will do at some point down the road, and the impact of international relations, very much a part of my history as well. Also had a great opportunity, also invited by a former Attorney General, a former Deputy Attorney General, to serve as a leader in litigation for the U.S. Attorney's Office in Western Michigan, of all places, in Grand Rapids, Michigan. So a great opportunity there as well. And finally, let's come right back to Waukesha, right back to where we are today, here in the studios of WAUK 540 AM 101 FM, the Shaw in Waukesha. Great pleasure to spend time because I live right down the street here in Brookfield, in this county, in this community. Waukesha is also my home, and we'll also tell you that on a regular basis, as I said yesterday when I was here, a great opportunity to be here on a regular basis. Enjoyed presentations and discussions with many of you at the Clark Hotel, just a few blocks from our location here. Great opportunity there, and also from time to time on stage, believe it or not, at the Waukesha Civic Theater, also just a couple of blocks down the street from where we are here at WAUK in downtown Waukesha. Right after the break, we're going to get back into the substance of our program, Morning Cannolis with Jim Santel. I'm here in the studio with Connor. We're going to come back and also take your questions, observations, as we talk this morning about one of those major issues, firearms in America. Right after the break.
Take this message to my brother. You will find him everywhere. Wherever people live together. You don't know me, but I'm your brother. I was raised here in this place.
And we are back. This is WAUK in Waukesha, 540 AM, 101 FM. This is the Shaw in Waukesha, Wisconsin, but also broadcasting throughout the state, other places in the Midwest. And I should also indicate that this program is going to be replayed again tomorrow morning on regular Sunday mornings for those of you who are unable to join us live right now. And this is Jim Santel. This is the first program that we're doing in the inaugural series of programs every Saturday morning, 9 to 11. We're calling it Morning Cannolis with Jim Santel. And yes, indeed, Connor and I have some variation on a cannoli this morning. Maybe we'll get the real deal down the road. Again, Jim Santel with you. Also going to be taking your questions and comments beginning perhaps a little bit later at this hour and then certainly the second hour of our time together. That number here at the Shaw is 844-967-2789. Write that down, memorize it so that when we're ready to have your phone calls come in, you are set to go as well. Again, this morning and in future mornings, we're going to do a little bit deeper dive into some of the very serious issues that are confronting us, perhaps from time to time, some of the non-serious issues, sampling those news desserts of the week, as Brian and others have said, again, with a lot of focus because of my background on law and government and justice in America, attempts that all of us undertake to deliver it to all people on a regular basis, sometimes with success, sometimes without. Again, my great thanks to Mike Crute, this wonderful staff here at WAUK, for inviting me to be with you, coming into your homes, your businesses, and right here in downtown Waukesha. I promised right before the break that we would get into one of the serious issues of our day, and that plainly, from this past week, weeks, months, years, it's a focus on firearms in America. I don't need to review for any of you, the history of certainly recent weeks, but also recent years of firearm deaths in America, the significance of those, the importance of those to our life and our livelihood. There was a very interesting report the Centers for Disease Control issued not too long ago, indicating that we reached the highest level ever recorded in United States history in 2020, the first year of the pandemic, as gun-related homicides surged by 38% in 1 year. That's an historic increase by any measure. Highest level in over 25 years. The acting principal deputy director of the CDC, a doctor named Deborah Hurry, said more than 45,000 Americans died in gun-related incidents throughout the pandemic in the United States, the highest number on record that federal and other data show. And significantly, that violence has had a dramatic and unprecedented toll on our communities of color. And the early data suggests that that trend has regrettably, unfortunately, horrifically continued through 2021 and even into 2022. More than half of those gun deaths we know in past years and certainly in this year are a result of suicides. That number also did not substantially change from 2019 to 2020. The overall rise in gun deaths was 15% in 2020, and that too, a very, very significant, sobering statistic for all of us, even here on a Saturday morning. So we're going to spend some time getting more into not just the stories behind that gun violence, but talking about the law. And talking about something that I've often chatted with Mike and Dom and others about during the course of the week, and that is the United States Supreme Court. And what the Second Amendment says, what it doesn't say, what our highest court has told us it means. Revisiting that this morning, and yes, getting back to my tease about Justice Antonin Scalia, my former professor at the University of Chicago Law School, who taught me administrative law many years ago. Chatting about that case, we'll get into that in just a few moments. And then probably in our second hour, talking with you and taking your questions, your comments, your observations about something else the Supreme Court is going to be doing this month, maybe at the latest early next, but certainly the next 4 to 6 weeks, deciding a major case when it comes to constitutional rights and gun possession, gun use, gun transfer, gun manufacturer, all those kinds of things. And so we're going to get into that right away. And let me begin this brief tutorial, if you will, again, inviting your questions along the way later this hour and certainly next hour at 844-967-2789. Connor and I here in the studio to take your calls and to respond to those. Let's begin with a real fundamental notion. We have chatted about this before on those many opportunities that I've had to talk with you and with Mike and Dom and others during the course of the week. Chief Justice John Marshall, in a case called Marbury versus Madison, one of the central seminal cases in our national history, said this. He said, "It's emphatically the province and the duty of the judicial department to say what the law is." He said that in 1803 in this case called Marbury versus Madison. What's the significance of that? That was the first time in our nation's very young history at that time that the court, the highest court, said, you know what? We're not just going to resolve the disputes that are set forth in the Constitution that James Madison and George Mason and others wrote into that. We're also going to tell you along the way as we resolve those disputes what the law is. We're going to take pieces of legislation, we're going to take actions by our government and determine whether they're constitutional or not. We're going to interpret the laws, we're going to do all that. That came from 1803, Chief Justice John Marshall, Marbury versus Madison. Emphatically, he said, the province and the duty of the judicial department, meaning the judiciary, the federal courts, and the U.S. Supreme Court in particular, to say what the law is significantly, like so many other things we've talked about. That concept, well, it's sort of implicit in the Federalist Papers and sort of can be read into the penumbra of things that the Constitution sets forth. It's not explicit in the Constitution, but we now know and we accept it a couple of hundred years later as basic fundamental understandings of what our judiciary does. And so with that commission from John Marshall in the very early 19th century, let's talk about what the Supreme Court has done when it comes to guns and the intersection between the United States Constitution, the Second Amendment in particular, and then also the rights that you have under the Constitution, what those mean and what those do not mean. We're going to talk a little bit more in the second hour about the actual text of the Second Amendment. Let's jump into this fundamental concept of trying to interpret what the Second Amendment really means, what its import is, and as you all know, the Second Amendment says this in linguistic language that is perhaps a little bit difficult to follow. It says a well-regulated militia. being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Following all that, James Madison, a great scribe, along with George Mason and others, but not necessarily the way that we'd write it today, but a huge focus there on the notion of militia. We'll talk more about that in the second hour, as I mentioned. But what does that mean? What does that Second Amendment right mean? And even as we invoke that in 2022 and in certainly years before and years to come, what should it really mean and what doesn't it mean? And so you should know that on four different occasions, until fairly recently, just about 14 years or so ago, the United States Supreme Court, in addressing what Article 2, the Second Amendment, actually means, those amendments to the Constitution, what that Second Amendment means, explicitly declined, refused, did not say that there is an individual right to gun ownership. They specifically said that the Second Amendment, that we now seem to understand as incorporating that right for reasons we'll get to in just a moment or so, is the Supreme Court on a regular basis, four different explicit occasions in our nation's history, up through and including 2008, early 2008, declined to say that that particular amendment to the Constitution, the Second Amendment, prescribes and establishes for all of us a personal, individual, as opposed to the right of the people generally to have a well-regulated militia. First, never ever before had they said that there was an independent, individual right to gun ownership. That's our history. That is a significant part of our national history under the Constitution. So what happens? Well, in 2008, the United States Supreme Court releases a case called District of Columbia versus Dick Heller, Heller, 2008. It is now 14 years old. This is still to this day good law in the United States of America. Heller is still the leading case as we get together here at 9:45 on a Saturday morning here in Waukesha and throughout Wisconsin, other places. This is still good law. How did that come about? Well, the District of Columbia had passed a law that basically said that when it comes to gun ownership, even inside your own home, you can't own a gun, has to be disassembled. You can have the pieces there, but pretty much restricting almost completely in the District of Columbia your capacity, your individual capacity to own a weapon. And again, up until that time, the United States Supreme Court had never ever said anything about an individual right to gun ownership. So what happens is Dick Heller looks at that and says, you know what, I think that's wrong. He says, I'm going to appeal that decision. I'm going to address the accuracy, the constitutionality of that District of Columbia law. I'm going to take it into federal court. I'm going to challenge what they have done under the Second Amendment. And lo and behold, for the first time in our nation's history, in 2008, the United States Supreme Court said that there is, in fact, under the Second Amendment, a protection of an individual's right to possess a gun disconnected with service in a militia, that initial language in the Second Amendment, and also went on to say, and that you can employ that weapon, use that weapon for traditionally lawful purposes, including self-defense in your home. Let me say that again. Under Heller, 2008, for the first time in our nation's history, a majority of the Supreme Court says that you've got a constitutional right under the Second Amendment to have an individual ownership of a firearm. You can possess that gun in your home for self-defensive purposes. That's a big change in our national understanding of what the Second Amendment means, and it happened just 14 years ago. Justice Antonin Scalia, one of the lions of the Supreme Court, an icon of the Supreme Court, who is no longer with us, but nonetheless did have an awful lot to do with the jurisprudence of our nation, issued that opinion. In subsequent cases, a case called McDonald versus Chicago in 2010 and Caetano versus Massachusetts, a majority of the justices also found that the Due Process Clause of the 14th Amendment incorporates these protections under the Second Amendment into actions of state and local government. So it's not just the District of Columbia, not just this particular law, but the announcement of that fundamental right in Heller extends everywhere, including right here in Waukesha, Wisconsin, throughout the Midwest, other places in communities nationwide. So that's a very significant historical development by Justice Scalia, by a majority of the Supreme Court, and to this day, it remains good law. And once again, what does Heller say in this 64-page majority opinion? Again, encouraging, as I always do, listeners to go and take a look at that. If you're not out at the Waukesha Farmers Market, when you come back with your goods and products, take a look at Heller in 2008. 90 additional pages of minority dissents. So this is not without its dissenting views, but 2008, an individual right to gun ownership in America, in your home, for the purposes of self-defense. Now, why is that so very important? As we begin to look toward the future and what is about to come, significantly in Heller, in that case in 2008, the United States Supreme Court, from the pen of Justice Scalia, said this. Also said that there is nothing that from the time that a jurist named William Blackstone, a 19th century English jurist, commentators and courts have explained that this right to keep and carry a weapon is not unconditional, and that there are, in fact, limitations on that can, in fact, be imposed. And that is as much on the law of the state of all of the United States of America, including the District of Columbia, then as it is today. Writing for the majority, this is what Antonin Scalia said. He said that nothing in this opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Hugely important language. Went on to say in a footnote 26 that by identifying these particular ways in which you can, in fact, control this kind of firearm use and transfer, these are presumptively lawful regulatory measures, only as examples, list not at all being exhausted by any means at all. And so that's Heller. That is Heller. It remains the good law to this day. And so one of the commentaries I will offer to you as we begin to go into another break here and come back after the break is to talk with you about the fact that the Second Amendment today, yes, doesn't establish for every American an individual right to gun ownership in the home for self-defensive purposes, but it also incorporates, by virtue of what the Supreme Court said, by virtue of what Antonin Scalia said, also, as the President has said, as many others have said, that it's not unconditional. And you do, in fact, the governments, local, state, federal, do have this opportunity, obligation, I would say an obligation, also to impose conditions on manufacture, sale, transfer, use, all those kinds of things, and that leads us into a further discussion about what the Second Amendment does and does not mean in America today. Join us right after the break. This is the Shaw, WAUK Waukesha. This is Morning Cannolis with Jim Santel. We're chatting today about firearms, also going to be taking your questions and comments at 844-967-2789. And we're back for the final moments of this first hour on a Saturday morning, June 4th of Morning Cannolis with Jim Santel. I'm here at the studio at WAUK. I'm joined by Connor, my producer, and we're talking this morning about guns. critically important issue, tragic issue in America as we continue virtually every day, certainly every week, undeniably every single month to sample the horror, regrettably, that continues to be visited upon Americans of all ages, of all races, backgrounds, nationalities, all immutable characteristics, no one immune to the horrors of gun violence in America. We're going to chat in our second hour about some possible remedies to this. But right before the break, we were talking about what the law is today, and specifically talking about what the Second Amendment does and does not say based upon this case called Heller. District of Columbia versus Dick Heller, 2008, from the pen of Justice Antonin Scalia. And I was chatting with you right before the break about how the Second Amendment, according to Heller, does prescribe an individual's right to possess a gun in your home for self-defensive purposes, but that it also establishes, as Justice Scalia told us, opportunities, and I would offer prerogatives and rights of our government to make limitations on that. That is also a part of the law today under the Second Amendment. And it is important to understand then that the decision in Heller is both a declaration of the rights of individual gun ownership, which is sometimes equated completely with the Second Amendment erroneously, and an equally clear affirmation that governing options are out there to limit and, yes, to restrict them in the interests of public safety and security. Justice Scalia saying in Heller, the Constitution leaves the government a variety of tools for combating that problem of firearms-related violence, including measures regulating handguns. That's the Second Amendment today in 2022. The upshot of what James Madison wrote in 1791, the Second Amendment, and Antonin Scalia's lessons some 217 years later, is that the Second Amendment undeniably confers some rights, some authorities, legal entitlements, lawful prerogatives on all Americans to keep and bear arms. Yes, that is what the law is. And at the same time, I would offer to you that it also prescribes the right to be free from life and liberty compromising violence of the sort that we have seen in America all too frequently in recent times. And that can be accomplished through some rational, public-minded restrictions and regulations that are balanced and reasonable on the manufacture, the sale, the transfer, possession, and location, and yes, use of firearms in America. Even the dissents in Heller underscore that basic duality, if you will, of the Second Amendment, even to this day on June 4th of 2022. So on this, as we approach the 14th anniversary, Heller was issued on June 26th, almost just under 14 years ago this month. It is good and right in understanding all this to know what the Second Amendment says, what it says in its entirety, not just a right to gun ownership in the home, but also a right, and as I've said, from my perspective, an obligation as they take the oath of office of our elected officials, our appointed officials, to protect us and to use those skills, those opportunities, those provisions of the law to keep us safe and secure. Reasonable regulation, limitations on guns, also very much a part of what the law is today. That remains the law to this day as we go into the 10 o'clock hour and the first final moments of our inaugural program this morning. Let's talk about what happens after that. Well, again, that has been the law. Heller has been the law for the last 14 years until a couple of years ago. And this is the tease into the second hour, if you will. A couple of years ago, in the New York State, there was a follow-up case. We're going to call it Bruen, B-R-U-E-N, to distinguish it from Heller. This case is now pending before the United States Supreme Court, and it will be the first time in 14 years that the United States Supreme Court has revisited this issue of what the Second Amendment actually means, what it does not mean. And where does it come from? Well, the full name of the case is New York State Rifle and Pistol Association versus Bruen. And it comes about, as I said once again, as a result of New York law that basically imposes some limitations on the right beyond the home. beyond the home. And we're going to talk in the second hour about what Bruin portends, what the Supreme Court is addressing right now, and what that means for America going forward beyond June and beyond July, the summer of 2022. In our second hour, we're going to be inviting your questions and comments, 844-967-2789. This is WAUK 540 AM, 101 FM. Jim Santel, Morning Cannolis. Join us, stay with us, and join us again right after the top of the hour break.
No more need for worry. Take this message to
Yeah,
Might have to start a band.
I got it.
Learn about adopting a teen from foster care. You can't imagine the reward. Visit adoptuskids.org to find out more. This message is brought to you by Adopt US Kids, the U.S. Department of Health and Human Services, and the Ad Council.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
you don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
And good morning. We're back for the second hour of our inaugural broadcast. Very excited to be with you. Thank you so much for joining me. Also, Connor here in the Waukesha studios of WMK Waukesha, 540 AM, 101 FM. It's the Shaw in Waukesha, Wisconsin. Also broadcasting throughout the state, other places in the Midwest. And Mike Crute, who most thoughtfully invited me, kindly, generously invited me to take this spot on Saturday morning, tells me that this broadcast will also be rebroadcast on Sunday mornings for those who are not joining us on a regular basis on Saturday morning. But this morning we are live. We're live in downtown Waukesha. Connor joining me here in the studio for Morning Cannolis with Jim Santel. Every single Saturday, we're going to spend more time delving a little bit more deeply into some of the issues that Mike and Dom and others and I will chat about during the week as those news stories percolate up for your attention and your focus. And today, in this inaugural program, we're talking about one of the most serious challenges facing America in the 21st century, and that is firearms, and in particular, the onslaught, the devastation, the disaster, the crisis that is our firearms use and abuse, taking the lives of quite literally great significant numbers of our population. Right before the break and for much of the second portion of the first hour, I was talking with you about what the Second Amendment means historically, that up until 2008, the United States Supreme Court had not specifically said that there was an independent individual right to gun ownership. But that changed in 2008 when, in fact, Heller became the law of the land. And Antonin Scalia told us not only about the right of individual ownership in the home and use, but also the notion that you can, in fact, impose reasonable regulations and conditions on everything from the manufacture, the sale, the transfer, the use of weapons. That's also a part of the Second Amendment under this case called Heller. In this second hour this morning, as we continue this discussion on an otherwise beautiful Saturday morning of this very somber and very grave discussion of guns in America, we're going to chat about what the Supreme Court's going to be doing, frankly, perhaps this month, probably no later than the next 4 to 5 weeks, in a second case called Bruin, B-R-U-E-N. We're going to chat about where that case comes from in the 14-year wake of Heller, what the issue is there, specifically focusing on whether there is a constitutional right to use and carry firearms beyond the home on the streets of America, the sidewalks of Waukesha, other places throughout the United States of America, what that means, what is the dimension of that, and what kinds of conditions can be imposed even on that right, if indeed, as we suspect it will, the Supreme Court finds that there is such a constitutional right to own and use firearms beyond the home. We are going to be taking callers this hour and, frankly, every Saturday morning as we discuss some of these issues in greater detail. That number is 844-967-2789. We're thrilled to get your comments. delighted to have your questions as they come in. And before I get back to Bruin and the legacy of Heller and what we will likely anticipate from the Supreme Court, let's take the first of our callers. Mike is in Sheboygan. Mike, we're glad to have you with us this morning. What's your thought or comment or question today on Morning Cannolis? And Mike, are you there? I think. All right, Mike, you're there. Very good. Glad to have you with us. And Mike, are you with us? I thought I heard you there for just a moment or so.
I am here. I
Wonderful.
can hear you.
Okay, great. What's your question? I'm glad to have you with us.
Thank you. Congratulations on the new show. Really
Thanks so
appreciate
much.
your service to our sanity.
Right.
And I guess, hello?
Yes, go ahead, Mike. Glad to have you with us.
Okay. And I really appreciate this same discussion that you always provide us, but this is a great opportunity for you to get into the weeds. As a former Army officer and a former believer, from my vantage point, it seems that the flag, patriotism, and faith has been commandeered. In that light, knowing what the Constitution says and what the Bill of Rights and Second Amendment, written later, said, and I believe, if I understand your vita, you studied under Antonin Scalia. Is that true?
That is correct. I don't want to say that I was at the top of my class in the University of Chicago. I wasn't one of his clerks, but he was one of my professors, administrative law, and certainly knew him and got to know him a little bit. This is before, again, this dates me tremendously, but dates me because Antonin Scalia was about to be plucked up by Ronald Reagan, to be placed on the Court of Appeals, and then went on to the Supreme Court after that. So yes, a long time ago, but did know him as a professor.
Well, nevertheless, with your undergrad degrees from Marquette in English and in history, you were a human being before you were a lawyer.
That's
so my
correct.
question is, and I know you don't like to speculate, but that your comments this morning on what Antonin Scalia said about Heller, it appears to me that if he were alive today, he could not possibly have gone along with this bastardization or using of the Second Amendment as the blunt cudgel that is being applied to it. And at the very least, and this will be the vernacular, he must be rolling in his grave, seeing as how it's been taken over and basically used as a blunt weapon. I know you don't want to speculate, but I'm going to ask you to do so anyways, because I bet I'm not the only one asking this question.
Absolutely, Mike, and it's perfectly okay to speculate, right? Because that's what our talk radio is all about. I so appreciate your question, your comment, and your calling in this morning, because to underscore that point, yes, the language that I read from Heller, some of it's in a footnote or two, but most of it's key to the opinion. And so this is Antonin Scalia, again, this icon sometimes of conservative politics out there, but certainly as a jurist, someone who was articulating on a regular basis a very conservative view not that long ago, just 14 years ago, certainly in my lifetime, I suspect yours as well, Mike, saying that, yes, you've got this right, and it is joined with the same obligation, the right, the prerogative of government to impose conditions on that. And so when our present president says, as he did just a couple of days ago, that this right is not unconstitutional, he's not making that up. That's the law of the United States of America. And again, I would encourage, Mike, I know you do it and others do it, to listen religiously to this station, others. Take a look at what Scalia said in Heller. Read that language when he talks about all these kinds of things that governments can, in fact, and will do, should do to keep us safe and secure. That is as much of the law. And yes, I will speculate to say that, gosh, Scalia, if nothing more, was a man of precedent. And I would like to think, along with you, that today, if he was around to see the misinterpretation of what he wrote and the alignment of the Second Amendment almost exclusively with this notion that it's gun ownership and that's it, he would balk at that. And yes, maybe he is rolling in his grave, as you said, Mike, but he would certainly look back to Heller and say, that's not what I meant. That's not what I meant. I gave you this right to own guns in your home, but also the obligation and the prerogative of the government, local, state, and federal, to keep us safe and secure, and to do that by imposing regulations legislatively that are out there, and we'll chat more about those. So very much appreciate your comment, Mike, and could not agree with you more. Appreciate the opportunity to speculate and to go down that road. Thanks so much, Mike, for calling in. We've got another caller who's also calling in. We'll take that question as well, and then we'll get back to what the Supreme Court's going to be doing. Mark, you've been on the line for a little while. Thank you for calling in. Appreciate your comments and questions this morning as well.
Oh, not a problem. I haven't been on the line that long. Yeah, it's interesting how our judiciary and our lawmakers fail to, that they complain about, that's not enumerated in the Constitution. Madison made it pretty clear that they didn't enumerate everything in the Constitution that they might be called upon to do to promote the general welfare, and that it's interesting that some of our court judges, what the irony to me is in the recent thing coming out from Alito is that he says, well, it's not enumerated in the Constitution. Well, neither is the power of the Supreme Court to decide the constitutionality of laws. I mean, it's not enumerated in the Constitution. Of course, we've had this discussion before. That's whole Madison versus Marbury, and that where they assume that power for themselves. That that Alito is claiming of this power of the court to do whatever they want to do, and that. It's interesting because that's going to play out over a lot of things. I mean, they're going to. There'll probably be a Supreme Court decision on gun ownership and where you can carry your guns, and you'll be able to carry them everywhere, which is not what we want to see happen. What do we want to have? A world where politics are decided, like in the movie The Man Who Shot Liberty Valance, where the powers would bring in their thugs to come in and kind of intimidate everybody because they're wearing firearms wherever they go. And I'm a firearm owner, but I don't feel it necessary to go packing everywhere I go because society is not that unsafe where you need to be packing wherever you go.
Absolutely.
I mean, there should be limits on magazine sizes. I mean, I've brought this up before, is that what Bill Ruger actually penned in 1989, apparently in a letter to Congress probably after a mass shooting, they never intended his firearms to be for military-type firearms to be used for civilian use, and no honest man needs more than 10 rounds in his magazine.
That's correct. Sure,
I saw that nitwit from Florida, displaying his firearms, waving around, saying, well, this doesn't fit in this one, the 10-round magazine. Well, of course it doesn't fit because it wasn't designed for that particular firearm. Because I pull out a Natchez catalog that I got from a distributor that where they sell magazines, and you can get 10-round magazines for probably each and every of those firearms that he has.
All kinds of things that, again, make the practical application very important, right? And to go back to your initial point, Mark, which I could not agree with more, many of these things are not in the Constitution, including Marbury versus Madison, this notion that the Supreme Court's going to tell us what the law is. That's where it started. But, again, as we have chatted before, I think your articulation of this general concept, the Constitution's got to be a living document, right? James Madison, George Mason, these people that we revere, I revere, you revere, they would not understand it and be horrified by, frankly, many of the things that we do today, 200 years later, including this radio station, right? The lights in our ceilings, the cars we drive, the very products that we engage on a regular basis. And it's got to be a living Constitution. We talk a lot in the civil rights area about penumbras, and at some point down the road, we'll chat about this other case having to do with abortion rights and privacy rights. We'll do that some other Saturday morning. But your point, Mark, is so well taken, which is it's not there. The Supreme Court has got to have the prerogative to be able to expand on and make the Constitution living for today. And we're going to chat more about that right after this next break. I appreciate very much your comments, Mark. We're going to talk more about this next case coming up, but the Supreme Court is going to have another opportunity to tell us what the law is under Marbury versus Madison. Case coming out of New York called Bruin. We'll do that right after the break. So much appreciate the calls already, the comments, and we'll do more of that right after this break on Morning Cannolis with Jim Santel, WAUK Waukesha, 540 AM, 101 FM, The Shaw.
Fairly soon, the time will tell. You telling me the things you're gonna do for me.
This is Jim Santel. Morning Cannolis with Jim Santel, WAUK, 540 AM, 101 FM, The Shaw in Waukesha. Thank you so much for joining us this morning for our inaugural program, talking about in greater depth some of the issues we've chatted about during the course of the week. This morning we're talking about the very somber issue of firearms in America. Don't need to tell any of you about the impact that this issue, this concern has had upon quite literally lives and livelihoods, including here in Wisconsin, throughout the United States of America. Right before the break, we were chatting about what the Second Amendment does and does not mean. One of my frustrations is this complete synonymous understanding that the Supreme Court has said that the Second Amendment basically vests in everybody a right to own a firearm in the home and nothing more. That symmetry forgets the other piece of this, which is that the Supreme Court has also said that there's a right to conditions and limitations on transfer and to ownership and use and even manufacture of guns. And that's one of the reasons why regulations out there, which we'll chat about at the end of this hour, can in fact be imposed. We do have some callers calling in, and we encourage you to stay on the line. In the interest of moving to our next significant topic, I appreciate so much the callers calling in this morning. I'm going to move on to what's going to happen next in the Supreme Court, which is this case out of New York. I teased a little bit before the break. In 1911, believe it or not, in the New York State, the legislature enacted something called the Sullivan Act, and it made the issue of concealed carry permits at the discretion, the judgment call of local law enforcement. And the law states that to obtain a permit, the applicant, the resident, must demonstrate a specific need for self-protection that's distinguishable from that of the general community or a persons engaged in the same profession. That's a lot of lawyer stuff, right? A lot of legislative language there. But that was the law in the state of New York and remains the law to this time. So what happens? Well, again, to truncate this a little bit, over time, plainly, the various government entities in the state of New York follow that and are certifying or not certifying the private use and carry of weapons in the public domain beyond the home in the streets of New York. And eventually, two folks named Robert Nash and Brandon Cook, Nash and Koch. They're a part of a group called the New York Rifle and Pistol Association. They apply for a permit under the Sullivan Act, and New York State says, you know what, you can't have it. Nash, for example, sought a permit for handgun after a string of robberies in his neighborhood, but he was denied that right because he couldn't prove a need in the public domain for self-defense. And so as a result of that, Mr. Nash, Mr. Cook, and others, the Rifle and Pistol Association, say, you know what, we think in the wake of Heller that it should be expanded to ensure that we've got that right beyond just our homes. We're going to go beyond that onto the streets of sidewalks of America. And so they challenge the New York law. And they challenge it on the basis that the judgments entered with respect to their applications were flawed, were not based upon a proper constitutional analysis, and that they, in fact, should have a right under the Constitution, apart from the New York authorization process, to own a firearm and to use it, to carry it in an open and unadorned setting in the streets of New York and other places. And so that was the issue. Eventually, it comes up to through the lower courts, and they appeal to the Second Circuit and an appellate court. They affirmed the dismissal of the case by the district court in August of 2020. And along the way, one of the superintendents for the New York State Police, his name was George Beach, he's replaced by a fellow named Corlett, ultimately by a fellow named Kevin Bruin in 2021. And Bruin was subsequently named as the defendant in this lawsuit brought by the New York Rifle and Pistol Association and by Nash and Koch. That's how we get the case before the Supreme Court. Nash and Cook looking at all of those rights that they may or may not have, coming up to the Supreme Court. And what does the Supreme Court do? Well, this is the case that is presently in front of the United States Supreme Court. And we know some things. We know some things about what the Supreme Court will likely do. It was argued. It was argued by the representatives of Cook and by Nash and the Pistol Association way back in November of this past year. And the question the Supreme Court decided to review was fairly limited. The question whether the state's denial of the petitioner's applications for concealed carry licenses for self-defense violated the Second Amendment, okay? So the question is whether or not Heller, which we talked about in the first segment, the first portion of our time together this morning, whether that, in fact, should be extended to cases and situations beyond the home into the streets of America. The petitioners, the New York Pistol Association, represented by Paul Clement, who is actually from the state of Wisconsin, a former Solicitor General during the George Bush administration. He was arguing on behalf of the National Rifle Association that, in fact, there is a constitutional right to carry beyond the home, opposed by Barbara Underwood, serving as a Solicitor General for the state of New York, defending the law. And that argument back in November is going to be the subject of our discussion right after this next break. We're going to tell you about what the justices said, gives us a very good sense of what they probably will be doing very shortly, probably in the next weeks, in the month of June, maybe into July and beyond. For the first time, again, in 14 years, telling us what the Second Amendment means, coming up right after the break here on WAUK 540 AM 101 FM.
Telling me the things you're gonna do for me. I ain't blind and I don't like what I think I see. Taking it to the street. Taking it to the street. Taking it to the street. No more need for running. Taking it to the street. Oh, no. Take this message to my brother.
Devil Radio.
And we're back once again. This is Morning Cannolis with Jim Santel. I'm your host, Jim Santel. I'm joined here in the studio in downtown Waukesha by my producer, a wonderful young man named Connor. We are here this morning to talk about a very somber issue in America, and that is guns, and specifically, what are the legal underpinnings for understandings about what the Second Amendment does and does not mean? Up to now this morning, we've chatted about the language of the Second Amendment a bit. Talked about this case named Heller, decided by a majority Supreme Court 14 years ago this month, authored by Justice Scalia, saying that, yes, indeed, you've got a constitutional right to possess a weapon in your home for defensive purposes, but also, very significantly, from the pen of Justice Scalia, telling us that you have got also a right, I would offer, for your elected officials, your appointed officials, to impose those reasonable, rational restrictions, limitations on manufacture, sale, transfer, ownership, use that keep us all safe and secure. The basis for much of the legislation proposed in states and that the federal government, not all of it, as we know well, adopted and passed by our legislative bodies and our elected representatives. So right before the break, we were beginning to get into this New York case that is going to be decided sometime in the next, I would say, 4 to 5, 6 weeks or so. It's called Bruin. Bruin, the official name is New York State Rifle and Pistol Association versus Bruin. Supreme Court has before it the issue now of whether or not the decision in Heller should be expanded to acknowledge, to embrace the notion that the government cannot in any way, including authorizations, including applications for concealed carry, restrict in any way your right under the Constitution to use and carry a weapon outside of the home. That's basically the focus of this Bruin case. We know some things about what the Supreme Court will probably do, and I'm going to make some predictions here about that in just a moment or so, but we know those things because this case was, as I indicated right before the break, argued before the Supreme Court way back in November 3rd. And at that time, as I said, Paul Clement, former Solicitor General in the U.S. Department of Justice, representing the National Rifle, the New York State Rifle and Pistol Association, and Barbara Underwood, who was representing the New York State also served as an acting Solicitor General of the U.S. between the Clinton and Bush administrations, both of them with great government experience, lots of time spent arguing cases before the Supreme Court. They were arguing this case, this very issue, before the United States Supreme Court in November, and again, very soon, the justices to issue a decision on this, first time in 14 years, telling us what the Supreme Court believes and what the law is when it comes to the Second Amendment. So what do we know from that argument? Well, Chief Justice John Roberts played a major role. Plainly, John Roberts is very skeptical of the legitimacy of this New York law that imposes upon the petitioners here this obligation to get authorization by the government to carry a handgun in public. Roberts basically said the Second Amendment protects a constitutional right just as the First Amendment does. People seeking to exercise either of those rights, he said, during the course of the oral argument in November, should not have to demonstrate to the government that they have a good reason or special need to do so. That's our Chief Justice. And so he went on to say, you don't have to say when you're looking for a permit to speak on a street corner or whatever that, your speech is particularly important. So why, he goes on to say, do you have to show in this case, convince somebody, again, this is his exact quote, that you're entitled to exercise your Second Amendment right by virtue of submitting an application and getting permission. So plainly, John Roberts is very skeptical of this New York law, as are a majority of the members of the Supreme Court. This, as in other cases, pretty much breaking down so-called partisan or political lines, likely that there will be at least 6 justices finding that this New York law is unconstitutional. But before we get there, also note that like Heller, the Chief Justice, as did others, and we'll chat about that in just a moment or so, the Chief Justice was also among those who said that guns could be barred at certain places that might be especially sensitive or need to be secure. And so he identified, for example, subways or public protests. He was talking about Yankee Stadium, Times Square in New York, obviously New York venues, college campuses in New York City. And basically suggesting that even though there may in fact be a constitutional right to carry a weapon outside of your own home, that right probably should be restricted, conditioned, as Scalia would say, on where you are. And so a lot of exchange between the justices and between the attorneys arguing this case. At one point, Mr. Clement, arguing on behalf of the petitioners and New York State Rifle Association, said, carrying a firearm outside the home is a fundamental constitutional right, one that's allowed with few restrictions in many states. He said those states included major cities like Phoenix, Houston, and Chicago. And Justice Elena Kagan, obviously on the opposite side, if you will, of the Supreme Court bench when it comes to Chief Justice Roberts, says that most people think that Chicago is like the world's worst city with respect to gun violence. And so makes that point. We'll get back to cities down the road. Brett Kavanaugh, to go back to the other side, said the court should limit its ruling to what he called the permitting regime. In other words, focusing just upon this authorization piece. We don't have to answer all the sensitive places questions in this case, some of which will be challenging, no doubt. But once again, what does that mean? That means that Kavanaugh likewise recognizes that there must be some limitations on this public right to carry a weapon beyond your home, and that the Supreme Court will probably articulate a view that there do need to be some restrictions based upon sensitive places like schools and like public places where the public convenes, subways, places of transportation, and that maybe the sensitive areas, while they can't be defined, are very important. They will be the subjects of future litigation about what is and is not sensitive. In other areas, Justice Roberts said, it's the purpose of the Second Amendment to allow people to protect themselves. That's implicated when you're in a high crime area. It's not implicated when you're out in the woods. Again, drawing this distinction between various places where this extended view of the Supreme Court might in fact apply. Justice Alito, who has been much in the news in connection with the leak of the case involving abortion rights and privacy rights, we'll talk about that in a future time, asked whether people who work late in Manhattan, he said this, it might be that somebody who cleans offices, it might be a doorman at an apartment, it might be a nurse or an orderly, it might be somebody who washes dishes, would be granted a license if they said that they had a dangerous commute through a high crime area. And Justice Alito went on to say again during the oral argument of November, they do not get licenses. Is that right? And Ms. Underwood, representing the state of New York, said that's generally correct. The core right to self-defense, she said, does not allow for all people to be armed for all possible confrontations in all places. And significantly, inside this large discussion among the Supreme Court about what the Supreme Court will view, the Second Amendment says, this notion of limitations as well. There was repeated reference to something called the Statute of Northampton of 1328. When I'm here on a regular basis in the week, I know that Dom and Mike routinely invoke the Statute of Northampton of 1328. It did, in fact, forbid carrying firearms of any kind, again, a very different time and place in the 14th century, to fairs and markets. And it's often cited by some proponents of gun regulation as evidence that the founders, James Madison, George Mason, the Second Amendment, the people who presumably wrote the Second Amendment and understood what they meant by it, did not intend the Second Amendment to preclude limits on public carrying of firearms, but nonetheless that there should be limitations on the places where you can, in fact, do that. Clement went on to say that the statute was not to be understood as a general prohibition on carrying outside the home, but was a prohibition on carrying unusual and dangerous weapons or using weapons in a way that terrorized the public. So lots of discussion back and forth. Justice Breyer weighs in, as did Justice Kagan, on the same issue. And along the way, the important language from Heller was invoked. That is, nothing in an opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms. All those are the things that Antonin Scalia said way back in 2008. Finally, an interesting exchange between the Chief Justice and Mr. Clement and others about whether or not the states could say that you're not allowed to carry a weapon on a university campus. And Mr. Clement said, I think the answer to your question is yes. Justice Kagan seemed to think that that was an important concession. She said, anybody can walk around the NYU campus, referring to New York University's many buildings in and around Greenwich Village, those who've been there. Mr. Clement responded to laughter. NYU doesn't have much of a campus, to which Justice Kagan and Justice Breyer disagreed. To my mind, they said, to more laughter, I think NYU does have a campus. So a little bit of levity, even inside this very important discussion among the Supreme Court about what is coming up next. And again, the question about whether or not Heller should be expanded in this case called Bruin beyond what the law says as we get together here on June 4th of 2022. We've got another caller on the line. Let's take that call. Dick from Madison calling in. Delighted to have you calling in, Dick. What's your comment or question this morning about this all-important issue of the law, the constitutionality, and guns in America?
Well, I had a different question. It was about William Barr and Merrick Garland, if it's all right.
All right, sure. Go ahead.
The case that was thrown out this week, or the man that was acquitted, the former attorney for the Clinton campaign.
Mr. Sussman.
William Barr was the person who put Durham on that, correct?
That's correct, right.
Now, in your mind and mine, in mine, don't you think Merrick Garland now should just squash that permanently? I mean, from what I see, William Barr has been excellent at one thing, gumming up the works and changing the story around so that, we're not on what we're supposed to be on.
And
in other words, the January 6th.
And undeniably, you've got your facts just right, Dick. There was no doubt that William Barr appointed U.S. Attorney Durham to review this question of whether or not the FBI and others had engaged in this entire investigation that resulted in the Mueller report. Obviously, Bob Mueller is authoring this very expansive report on whether there was Russian collusion with the Trump campaign, whether there was obstruction of justice, but focusing especially on any connections between the Trump campaign and, in fact, the election and Russia in particular. This past week, again, Mr. Sussman, who is a product of the Durham investigation, acquitted for purportedly lying to the FBI about who he was representing. I do share your view, Dick, that now it has come time, even though there are a couple of more prosecutions out there, this investigation has been going on for a significant period of time. I would agree with you that it is now time for our present Attorney General, Merrick Garland, to bring that to a conclusion and to basically announce what we've all indicated, which is that there was that there plainly was some relationship between the campaign and Russia. That's in the Mueller report, not a finding of conspiracy, but nonetheless a finding of some obstruction of justice when it comes to the investigation itself. So appreciate the call very much, Dick. We've got a number of other callers on the line. Let's take those right away. Let's go to William Zimmerman. William, you're on the line. What's your question or comment this morning? Good to have you with us. And William, we'll take your call when you're ready to talk with us this morning. William, are you there? Yes?
Yeah, I'm there.
All right.
Can you hear me okay?
I can hear you just fine. Go right ahead. Glad to have you with us.
Okay, here goes. Glad to be here. Let's protect children, not guns. Going into the midterms, we have to make a stand. Are you going to protect the children, or are you going to protect the guns? You can't do both. I'm a gun owner. I really believe this has just gone off. The wheels have come off the bus. We pass out guns like candy, no accountability. There's nothing wrong with owning a gun if you're properly trained, licensed, and insured. But anything after that, it's the Wild West. My dad predicted it before he passed away that this would happen, and we do have the Wild West in our country right now, and we've got to stop it. So, go ahead.
No, I was just going to say, William, the reality is that polling shows that I think most Americans agree with you. That again, to make this about the law once again, and as Scalia said, Heller says, probably the Supreme Court's going to say as well in this Bruin case, you can impose limitations on the right, and those conditions should be for things like transfer and sale and possession, and also the places where you use it, including, to your first point, schools, right? Those have got to be secure places where guns can, in fact, be prohibited. And the notion of going in the opposite direction, you can't have an unconditioned right to carry weapons in all places. I agree with you entirely. So thanks so much for the call, William. We appreciate that very much. Right before the break, let's take also a call from Joelle. Joelle, glad to have you with us this morning. What's your thought or question? Delighted to have you with us. And go right ahead, Joelle.
Well, thank you for taking my call. Actually, this is CJ. But, your party wants to take away rights for law-abiding citizens, and it's only okay for William's grandson to own the gun he wants, but he wants to restrict everybody else's grandson. Your party, part of the problem is that your party, your Democrat Party, and DAs all across the country have been proven weak on crime. But now you want to restrict law-abiding citizens, and like the criminals are going to turn in all their guns now, and the city of Chicago is going to be safe. Let's see how safe it is this weekend.
Well, and let's talk about law and the imposition of law enforcement and things to keep us all safe and secure. DAs and U.S. attorneys and others in law enforcement, I'd like to think without partisan bias, they enforce the law that's out there. They make certain that the law, understood by the Constitution, by the Supreme Court, is enforced. And you know what? The law does not say that any party, and I bristle somewhat at the notion that some of this is animated by partisan politics. politics. Law enforcement, as I said at the outset, should be apolitical and should be nonpartisan. Republicans and Democrats should be concerned about ensuring safety and security and following the law. And as we're discussing this morning, the Supreme Court has said that there is a right of gun ownership in America, probably going to be reaffirmed in this Bruen case, but you can also impose limitations on it. And my point right before our conversation here, CJ, this morning was and is that all that comes with reasonable restrictions. And they're not unconstitutional. They're the things that keep us safe, even acknowledging that under the Second Amendment and Heller, there is this right. So we appreciate the comment. We appreciate the call very, very much, CJ, and look forward to our future conversations. Right before the break, let's take one more phone call. Charles, you're also on the line. Your thought, your comment this morning as well. And Charles, you were with us. Thanks so much for calling in.
Hi. I just want to say, Jim, I'm glad you have a show now, and I hope this is the start of something more, that you have a full-time show during the week also. I've enjoyed listening to you when you've filled in or been a guest.
Thank you so much. I appreciate that comment, Charles.
Yeah, and you have a very thoughtful point of view. With this gun thing now, it's turning out to be so difficult, and people's rights and stuff like that, and I think there's got to be some common ground and some common thought of what is too far. Is having a rifle, that an 18-year-old can buy. It seems like maybe it should be a 21 for them. For the younger people, I don't know what the cure is. Honestly, it's a difficult question.
Sure.
Obviously, mental health is a big issue though too, and that seems to be neglected since Reagan, I believe.
It is a difficult question, Charles, right? No, I appreciate very much the comment and the calling in this morning. That's exactly the kind of conversation we want to have. And it leads most appropriately, Charles, to the discussion we're going to have maybe in the last few moments of our time together this morning, both CJ and Charles, others who've called in this morning. What do we do about this? What do we do about these reasonable, rational restrictions that we can, in fact, impose, not only in the wake of Heller, but likely in the wake of Bruen as well? The Supreme Court is not going to say that there is a completely unfettered constitutional right to carry guns in all places. The majority has signaled that in November, and so with a fair bit of reading the tea leaves on this, we can anticipate that while Bruen will, in fact, expand Heller and say that there is a broader right under the Constitution. Here it is, again, many years later after Heller. Nonetheless, they're going to do exactly what Scalia said initially. They're going to impose some regulations and some restrictions on that with respect to places. And we're going to spend a lot of time, I suspect, as Americans after this next case is issued, deciding what those specific kinds of places are and what they aren't. But along the way that we know the kinds of things that can, in fact, be imposed, those things that can, in fact, address those issues. And Charles, as you indicated, we know what those are. And we think that with some clarity from the Supreme Court, that they can, in fact, be legislated. We talked about things like extreme risk protection orders that enable you to go to a judge and say, you know what, Jim Santel might be a threat to himself or to others. And for that reason, temporarily, for his safety, the safety of the community, we should make some restrictions on that. In addition, there are things like, barring semi-automatic weapons. We did that for about 10 years in the past, limiting actually the kinds of weapons that you can, in fact, do under the Constitution based upon what Heller and probably the Bruen case will also reaffirm. Restrictions on age to purchase weapons, universal background checks, the kinds of things that are necessarily imposed constitutionally under Heller. If you go into a gun shop, getting that background check, closing up the gun show loophole, and also a whole variety of safety issues related to home use and home access to guns. All those kinds of things can be legislative. Those are the kinds of things that legislators in Madison, other places around the country, in the United States Congress are talking about right now. There is this bipartisan group looking at the kinds of things that might, in fact, be regulated, be conditioned constitutionally, as Heller said, and I would offer, again, by way of the future, also indicating that under this Bruen case coming out fairly soon, will also be properly legislated to ensure that the Second Amendment right to gun ownership and perhaps even to carry in public is also conditioned in a way that keeps us safe and secure. All sorts of legislative possibilities out there. We're going into our final minutes here, but before we do so, let's take another caller. That's Larry. Larry, you're on the line. Your thoughts as well this morning. Larry, I think we've got you on the line here. Okay, maybe no longer. All right. So Larry was going to chat with us, but has taken off. Let me talk more about, as we go into our final moments here, about what this means generally and some lessons from the overall discussion this morning. Again, very much appreciate the conversations with those of you who've called in, and we'll look forward to more of that in our future shows. The discussion is all important, and that's what certainly this talk radio program and all the talk radio programs on all sides of the political aisle should be all about. People addressing sometimes differing opinions, but doing it in a way that finds this balance. And that's where I'd like to begin to conclude today. The balance that the Supreme Court is trying to articulate here is recognizing, whether you agree with it or not, whether you agree with Scalia or not, that the legacy, if you will, of Heller is that you've got some constitutional rights of an individual nature to own and use firearms in the home and now probably beyond the home, as Bruin has decided. That right is also conditioned. And it's in the midst of that great middle that is out there that Americans should, in fact, be able to find some agreement when it comes to things, as I just mentioned, like these ERPOs, like barring certain kinds of highly volatile weapons of the sort that I saw only in Iraq, and now we see them in America routinely. Background checks, home safety capacities, other things that educate us all. That's the balance we need to provide when it comes to this very volatile issue. I'd like to think that even in America, as divided as we are today in 2022, we should be able to find that place where all of us can come together to keep us safe and secure, to address the kinds of things we continue to be victimized about in recent weeks, nonetheless acknowledging our constitutional rights as they have been established and understood today by the United States Supreme Court. It has been my great pleasure to spend the morning with you. We'll be back again next week. More Morning Cannolis with Jim Santel. Connor back in the studio with me. Thank you so much for joining me in this inaugural program. A weekend review of some of these important stories this morning. Guns. Next week, probably talking more about what the big story of next week is, which is the January 6th Commission and its important hearings publicly viewed next week. A pleasure. This is WAUK 540 AM, 101 FM, the Shaw and Waukesha. Have a good and safe and healthy week, everybody, and we'll be with you again next Saturday morning. Good morning. Take care.